Let's just check. Okay, it's recording. Great. I'm Vanya Karth. I think some of you know me. I see a lot of familiar names on the list, which is lovely to see. I'm the director of the DGRU and of JIFA, based here at the University of Cape Town. And as I think you've all been informed, we're running a project that aims to give support to the specialized commercial crimes courts as well as the tribunal, but also to the lower courts judiciary more generally. So this is the start of our webinar series. We're very excited about it, and I think it's going to be a great series going forward. And I think we've got a fantastic person kicking us off in the person of PJ Schwikkard. I will do a quick little introduction. So PJ has been in public law at UCT since 2001. Her primary research interests lie in the intersection of human rights, evidence, and criminal law and procedure. And I'm pretty sure most of you know her book. She's the co-author of Principles of Evidence, which is, I think, is it the sixth, PJ, or the sixth that has just come out recently? And she's also been the lead author on a number of South African Law Reform Commission reports. So I think she's well placed to be speaking to the topic today. And just to say this, so the topics that we will be doing in the webinar series are topics that you have all asked for and raised. So if anybody has any more ideas that you want to send, we have a list, but we're always happy to have more. So you can just send them through to myself. I will put my email address in the chat so you can get it. And what we're also going to be doing is we will, sorry, let me just let in the 7 people in the waiting room. What we're going to do is so we will record the webinar. Our virtual clerk students who are also in the room, they're going to be creating a case law collection. So all the case law that is referred to in the webinar series, we will create a collection on Law Library. And then the full webinar will be there as an ongoing resource for you to use going forward. Okay, so I think we've got enough people in the room. So PJ, are you ready for me to share your PowerPoint and get started?
Yeah, I am.
Okay, let me find the right screen. And hang on, let's just get to beginning. There we go. And let me just get rid of my camera, and then it's all over to you, PJ.
All right. Good afternoon, everybody. I hope you've all had manageable days. 4:30 on a Monday afternoon probably feels quite late in the day. So we're going to speak about Section 35(5) of the Constitution today, and I know you are very familiar with it. And I look forward to hearing about your practical experience in applying this section to unconstitutionally obtained evidence. And I suspect I might have more to learn than you do this afternoon, but I will hopefully take you usefully through the background theory. So I'm going to start the webinar by taking you through the steps to be applied when considering the application of Section 35(5). And then I'll be happy to field questions. There'll probably be about 20 minutes of talking. When we get to the questions, please feel free, if you feel that you've got something to add to the answer or contribute in any way, please feel free to speak. I'm sure there's lots of shared expertise in this virtual room, and I certainly don't want to be the only person speaking or providing answers. Okay, so if we move to the second slide, the obvious starting point is the text of Section 35(5). It gives us the framework within which we work in excluding unconstitutionally obtained evidence. Before we start a close examination of the text, it's useful to always keep in mind the broad objectives of the section. And I'm going to use the words of Van Zyl, DJP, and Ndlovu. And this is what the judge stated. Section 35(5) seeks to strike a balance between competing interests. On the one hand, there's the need to preserve the authority of the Constitution and the entrenched rights of accused persons. And on the other, there's a public interest in maintaining the repute of the administration of justice. Okay. So you all know the text. It says evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. So in dealing with the threshold test, we move to slide 3. See where I am here. Okay. An accused who seeks to invoke section 35(1) must first establish that the disputed evidence was obtained as a result of a breach of a constitutional right. For section 35(5) to apply, it is not necessary that it is the accused's rights that were violated. It will also apply if a witness's rights were violated. An example is the Mtembu case. Can we move to slide 3? Vanya, are you there? Vanya,
Sorry, I am, but it's got stuck. So let me just figure out why it's sticking.
Okay.
Next, there you go. There you go. So,
okay, thanks. So the example I'm going to use to illustrate that it's not only the accused's rights that may be violated for section 35(5) to come into play is the Mtembu case. And in that case, the prosecution sought to admit a statement by a section 204 witness, as well as articles discovered as a result of that statement. This statement was made as a result of torture. And the court held that the application of section 35(5) was not restricted to those instances where the accused's rights were violated. And although the statement in question was not made by accused, but made by a witness, they declined to admit the statement or any of the articles discovered as a consequence of that statement. Section 35(5) also applies to the situation where the prosecution wishes to introduce evidence unconstitutionally obtained by private individuals. All right, Dube is your authority here. However, whether the evidence was procured by the state or a person acting in a private capacity might still be relevant in determining whether the admission of evidence would be detrimental to the administration of justice. I want to move on to slide 4, because on slide 4, we look at the discretionary peremptory interpretation of the section. Once it has been established that the disputed evidence was obtained as a consequence of a breach of a constitutional right, and the court must ask whether the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. Now, that word otherwise indicates that if the admission renders the trial unfair, it would be detrimental to the administration.
sorry, can we just ask you all to mute yourselves, please?
All right, in your trial, your court authority there is Naidu. However, it's also possible where admission does not render the trial unfair, that if the evidence was admitted, it would nonetheless be detrimental to the administration of justice. Now, a court has a discretion to determine whether admission of the disputed evidence will render the trial unfair or otherwise be detrimental to the administration of justice. Your SCA authority here is S versus M. But once a court has determined that admission would render the trial unfair or is detrimental to the administration of justice, then it must exclude the evidence. In other words, the court has no discretion to admit evidence that would render the trial unfair or otherwise be detrimental to the administration of justice. So we move to slide 5, where we start considering where would admission render the trial unfair. So the first question will always be, would admission render the trial unfair? And the nature of the constitutional breach is more often than not a good indicator whether there is a possibility that admission might render the trial unfair. If it is a breach of any of the rights set out in subsections 35(1), 2, or 3 of the Constitution, i.e. the rights accruing to arrested, detained, and accused persons, it might well be that admission of the evidence would render the trial unfair. But it is important to note that a breach of any one of those rights does not automatically mean that the admission of the evidence obtained as a result of the breach will render the trial unfair. The Constitutional Court has held that the right to a fair trial is a comprehensive and integrated right, the precise content of which has to be established on a case-by-case basis. Schwikkard and Cielo are your case authority here. It's the same case, Schwikkard and Cielo. Whether or not admission will render the trial unfair has to be considered holistically, and the courts will take a number of factors into consideration. Before considering the different factors, it's useful to identify upfront the competing policy interests. They must always be at the back of your mind. On the one hand, we have an interest in protecting citizens from illegal or irregular invasion of their liberty by the authorities. On the other, there's the interest of the state to secure evidence bearing upon the commission of a crime. Conviction of the guilty is also important to protect citizens' safety and security and a host of other constitutional rights, as we all know. So if we move to slide 6, we continue with this inquiry as to when admission would render the trial unfair. And it's against this background of competing rights that there are various factors that a court will consider. In determining the degree of prejudice to the accused and public policy, the court will take the following into account: the type and degree of breach. Fundwa is a very useful SCA case here, where there is a deliberate or flagrant breach of a constitutional right. The court is unlikely to admit the evidence. Conversely, a minor inadvertent breach might be a factor taken into account in admitting the evidence. The court will also consider whether the police conduct was objectively unreasonable. That will go towards trial unfairness. On the other hand, if the police conduct is objectively reasonable, it will be one of the factors that would favor admission of it. A breach of the privilege against self-incrimination is frequently arises as a basis for invoking Section 35(5). This often occurs when an arrested, detained, or detained person was not given the appropriate. The approach which the superior courts have adopted for purposes Section 35(5) seems to be that while the absence or inadequate furnishing of the constitutionally required warnings does have an adverse impact on the fairness of the entire process, it does not mean that admission of the evidence so obtained will inevitably result in an accused being deprived their constitutional right to a fair trial. The court, in making this determination, will make a value judgment by weighing up competing interests. For example, where the failure to give the required warnings to an accused is not done deliberately or is done in the interests of public safety, the court might find that trial fairness has not been negated. Conversely, where the evidence is obtained as a result of a deliberate failure to warn as part of a strategy to elicit evidence, admission of the evidence will be found to render trial unfair. There are quite a lot of cases on this issue: Sosi, Lottering, Pillay, Naidu, Nell, Tandwa, Tetiani, Impala, and that's not all of them. Whether the right to be given the required constitutional warning extends to suspects before they become arrested or detained person is not clear. There are conflicting cases, but at the least, such a suspect is entitled to be warned in terms of the judge's rule. Some of the cases you can look at are Sebian, Khan, Makala. Real evidence is another issue. Real evidence will more readily be admitted as it is not subject to manipulation and generally not considered to infringe the privilege against self-expression. But this is not always the case. And cases you might look at are Gumeda and SFR. Generally, the superior courts have shown a reluctance to admit real evidence that was obtained as a result of a breach of privilege. That really deals with the first leg. Would admission render the trial unfair? If it doesn't, we then move on to the second leg. Would admission be detrimental to the administration of justice? So this, I think, most often arises when you get evidence obtained as a result of a breach of the right to privacy. So when you have an unlawful search or seizure, or an unauthorized tapping of mobile or other communication. Now, there's an inevitable overlap between the factors taken into consideration when establishing whether admission would render the trial unfair or whether admission would otherwise be detrimental to the administration of justice. So don't get confused when you think, but we've already discussed these factors. Very often, there's a big overlap between the two factors at different inquiries. In determining whether admission would be detrimental to the administration of justice, balance must be struck between respect for the Bill of Rights and respect for the judicial process. Case authority, Impala. Now, at this stage, the second leg, when we're looking at whether it would be detrimental to the administration of justice, some weight is given to public opinion. And this is directly related to the requisite level of public confidence in the criminal justice system. Pereira versus Levin's case authority, as is in Corbo. However, this public opinion factor does not allow the court to disregard constitutional values in the face of a public call for crime control, and in promoting long-term value, a court should strive to play an educational role through its decision. I want to look at the factors, so we move on to slide 8, where we look at factors that will be taken into account in determining whether admission would be detrimental to the administration of justice. So we can say that evidence should not be admitted if admission would encourage police officers to ignore or overlook constitutional protections afforded to it. Lottering's case authority here. Evidence should be excluded if its admission might create an incentive for law enforcement agents to disregard an accused person's constitutional right. That was stated in the Pillay case. Police conduct carried out in bad faith is not tolerated, nor is police conduct that is objectively unfair. Okay, this comes up in a number of cases, Naidu, Henna, Mpala, Madiba. However, the fact that the police acted in good faith will not be sufficient to justify admissibility where the breach is a result of systemically bad practice. For example, incorrect training or incorrect departmental direction. So even if the police are acting in good faith, if this is a result of poor training or some other systemic bad practice, the court is going to be reluctant to admit the evidence. Cersei is a useful case on that point. Courts are often sympathetic to unconstitutional conduct, which was motivated by the need to promote public safety and urgency. Madiba is a good case here. And obviously the court will take into account the nature and extent of the violation. Mark's case, you can refer to on this point. Now, if there were alternate lawful means of obtaining the evidence, then the breach should be regarded more seriously. That's in cases. So if it was convenient or easy for the police to go about things lawfully, that will be considered very seriously if they fail to do. Then real evidence that pre-existed the breach is more likely to be admitted. Won't always be admitted, but it's more likely to be admitted. And your cases here are in Keys and in Lowville. And this really leads us to the next topic and the next slide, which is derivative evidence. Slide 9, derivative. Derivative evidence, we sometimes note as fruit of the poison tree. This is when the evidence in question was not directly discovered by unconstitutional means, but was discovered as a result of a clue given in the unconstitutionally obtained evidence. For example, a statement is made in breach of the privilege against self-incrimination. The court applies section 35(5) and finds that admission would render the trial unfair. The statement is excluded from evidence. However, reference to the whereabouts of a gun used in the commission of the offence is made in the statement. The police follow up on this. They find the gun. Is the gun automatically excluded from evidence? No. Seems that the court must treat the gun as a separate item of evidence and decide whether in the circumstances it is admissible or inadmissible in terms of section 35(5). However, where the initial breach involves a breach of the privilege against self-incrimination, the courts are unlikely to admit it. Pillay is your Supreme Court authority, Supreme Court for Appeal authority. Now, the court will take the following factors into account in determining whether derivative evidence is admissible. Always important, was it real evidence? Did it pre-exist breach, if it did pre-exist, the breach, that is a factor in favor of admissibility, not automatically admissible, but more likely to be admissible. The court will look at the nature and extent of the initial constitutional breach. Ferreira versus Byrne is your authority. So if the initial breach, for example, involved police violence, it's highly unlikely that the court will admit the derivative evidence. And you can look at Tandwa for that. If the evidence would inevitably have been discovered by law, this will be a factor that will favor admission. So the constitutional clue, the consequence of the constitutional clue was simply that the evidence was discovered sooner than it otherwise would have by other means, by lawful means. The court will be sympathetic. However, this does not mean that the police may just bypass procedural matters. So it can't be the reason that lawful means weren't followed was just because the police didn't find it. Depending on which leg of the inquiry is relevant, the usual factors applicable to determining whether admission would render the trial unfair or, depending on circumstances, otherwise be detrimental to the administration of justice, will apply to derivative evidence. When we speak of derivative evidence, we also think of Section 218, the Criminal Procedure Act. Now, how do the two coexist? Section 35(5) and Section 218 of the CPA. Evidence admitted in terms of Section 218 will always be subject to Section 35(5). It was unconstitutional. Okay. And the same applies to evidence that takes the form of admissions. We look at the requirements of the Criminal Procedure Act, but in any event, if it is obtained unconstitutionally, Section 35(5) can be applied to exclude it. I want to end my talking part by looking at a couple of procedural matters and civil, what do we do in civil cases? So as you know, as a general rule, trial within the trial should be held where the defense objects to the admissibility of the evidence, basis Section 5. That's DPP Transvaal versus Viljoen, SCA authority. However, a trial within a trial is not always necessary. For example, where the parties agree that the facts are common cause. Your case authority here is Kitson and Henna. Very importantly, a court must make a ruling on admissibility prior to the close of the prosecution case. Okay, this was dealt with in a very recent case. So what about burden of proof? And here the cases are conflicting. They're not very useful. Some say the defense bears the burden of proof. Some say the state bears the burden of proof. Others say there's no burden of proof. But I think the following appears plausible. Find your way through the cases. So the defense must allege, but need not prove, that there has been infringement of constitutional rights resulting in the acquisition of evidence. Factual matters in dispute must be proved by the state beyond a reasonable doubt. For example, where the defense alleges that the accused never consented to a warranted search, the prosecution must prove beyond a reasonable doubt it did. As regards the value judgment that a court must make as to whether admission would render the trial unfair or be detrimental to the administration of justice, there is no onus. Okay. Then, to finish, civil proceedings. The case authority here is Cone versus Superstone Mining, SCA case. Seems to be strongest authority. And it was held that Section 35(5) was of no application and applied solely to criminal proceedings. According to the SCA, Section 35(5) does not apply to civil cases. Nevertheless, the court did hold that a court has a common law discretion to exclude improperly or unlawfully obtained evidence. The common law discretion allows evidence to be excluded when its admission would operate unfairly against the person seeking to have it. Okay, I'm going to end on that, and I look forward to questions, and I look forward to you assisting me in answering the questions.
Thank you so much, PJ. That was fascinating, even for somebody like me who knows nothing about evidence. So with that, I think let's take 3 questions at a time so I can try and manage them. So if you could either put up your hand, if you, sorry, excuse me, guys. If you don't know how to put up your hand, then you can just put something in the chat, or you can just speak. Yeah, I'm not seeing a single hand. Is there nobody who wants to ask PJ anything?
I want to ask.
Go. Okay, yes, please. Go ahead. Please ask.
Yes. What I want to know, you're speaking to Cindy Siwe Malinda, ne? What I want to know is that from, let's take now, the lecturer has just mentioned that evidence which was found inevitably there, like objective evidence, will mostly be admitted, ne? Then if then the trial within a trial comes up, and already from the facts of the case, you've been made aware during the testimonies, or you're aware and alert to the fact that what the defense is saying has been unconstitutionally obtained is objective evidence which would been discovered despite and in spite the breach, if there's the breach. Are you allowed as a magistrate to say you will not go to a trial within a trial because the facts speak for themselves, or you have to go with the request by the defense to say trial within a trial, though you are aware that it's a waste of time?
Well, I think, you know, even if it is real evidence or objective evidence, that is just one of the factors that you must take into account in exercising your profession. So I don't think it should ever be a foregone conclusion, because it doesn't automatically lead to admission. It's
okay.
You have to look at it holistically in the circumstances of the case.
Thank you.
Thanks for the question.
Okay, we've got Levian Yengopal has got a question for us.
Thank you so much. When it comes to trials within a trial, the learned lecturer said to us that the test for admissibility is beyond a reasonable doubt, especially if Hello.
Hello. I think we could you perhaps start again?
Start again.
All right, yeah, I'll start again. You mentioned that when it comes to evidence, when it comes to deciding on evidence, whether to admit or not in a trial within a trial, especially as regards the prosecution, when it comes to a dispute of fact, and your example was a search warrant.
Yeah.
Then the court must make a finding beyond a reasonable doubt. Is that so?
Well, it's not. Okay, thanks, Levine, for that question. You know, I wouldn't lay my head on a block for that, because the cases are actually contradictory. So
yes,
when I put forward a plausible framework, that appears to be a view that would fit with some of the cases. But there's no SCA authority on it. There's no Concourt authority on it.
Yes,
Yeah.
because with respect, I feel, to make a finding of beyond reasonable doubt in a trial within a trial, which is only an interim part of the trial, it'll have so much of effect on the acceptance of evidence going forward, because remember, the totality of evidence only comes at the end, and then the trial within a trial, if you accept it, you read it into the record as though it's part of the trial. So if the presiding officer is going to make a finding that this search warrant is beyond a reasonable doubt, then it has repercussions on the fairness of the trial going forward. I would understand it to be that the admissibility of the evidence should be on a balance of probabilities, and then when argument is laid before you by the parties at the end of the trial, considering that the trial within a trial is a part of the proceedings, you cannot fall back on that. The court cannot fall back on it and say, and the party says, if you find in favor of the prosecution beyond reasonable doubt, and then the defense cannot argue at a later stage, but hang on, the search itself, when looking at all the other evidence, you made a finding, so it would be as though the trial proceeded unfairly all along.
But I think you're not, the burden of proof doesn't apply to the admissibility. It applies to, because what you're trying to find before Section 35 can even come into play is whether there's been a breach of a constitutional right.
Yeah, so that's the whole inquiry. Now, the police, well, the loose
it's not
example.
The whole inquiry, it's just the first inquiry.
No, it's okay. All right. Thank you for that. But I mean, if we're going to make a finding beyond reasonable doubt, what's your opinion then about the fairness of the trial going forward?
Well, why would if it was found that the search was not lawful, so if the police were unable to establish that the search was lawful, what would you ordinarily do?
Well, if the court makes a finding that the search was unlawful and you give your reasons, you would give your reasons on a balance of probabilities.
But given that you have to make a given that you have to make a ruling, you do have to make a ruling on admissibility.
Yeah, the ruling is made on the balance of probabilities. I only ask because I want clarity on this, because
yeah, I don't think there is clarity on it, because there isn't a case authority on it.
All right, so each case on its own facts.
Yeah.
But so then there's no universal test.
There isn't at the moment. If there was, if I could find it in the case law, I would tell you. And maybe someone else has better case authority for it. But I think I've looked at all the unconstitutionally obtained reported cases, and I cannot find a consistent approach.
Thank you so much. Thank you.
Have we got any more questions? Nobody?
Can I ask a question? If anyone's prepared to volunteer, what they find the most difficult thing about applying Section 35?
We've got no volunteers. Are we going to pick?
Can you kindly repeat the question?
Sorry, Cindy. I was just wondering if, I mean, what all of you in your experience found the most difficult thing about applying Section 35.
There we go. Yaki, your hand is up.
Hi, good afternoon. I suppose one of the things that come up is that, okay, and some of it's got to do with maybe prosecutors and practitioners not being all that well prepared and or know what they're supposed to argue, which creates part of our problems. But I found that when we do get the fruit of the poisonous tree argument, but very much the American version of it, kind of thing going around, which can just confuse everything, to be honest. And then we have had a couple of cases, I myself, and I know some of my colleagues as well, with, in particular when you're dealing with commercial crimes, where they had disciplinary hearings at the workplace. And they're trying to get that evidence in one way or the other. I had also one where they, MPA, in terms of the MPA Act, they can do that inquiry with the accused, where they try to get that in. So you get sometimes the all kinds of ways and means that people, and they don't necessarily bring it up under, a 35-5 or whatever, and they start arguing something else. But it's those more problematic areas. I mean, with the disciplinary hearing issue, I mean, that evidence is not even taken in a proper manner most of the time before that hearing, or the manner in which it was done, and all kinds of other things. So I suppose just some of those are sometimes some of the things that we find that, they just jump out here at you during the course of the trial, and you kind of, as presiding officer, need to be quite wary about these things and just ask the question, and then everybody will just look at you. I suppose some of my colleagues might have similar or even worse experiences with regard to this kind of thing.
Yeah. But, I mean, in relation to those extracurricular hearings, when quite often legislation allows for the party who then becomes accused to be compelled in those proceedings on the basis that the proceedings can't be used.
No, you're absolutely right. Often that there would be somewhere, but as a presiding officer, you need to be very aware of these things. And follow up on it, because it sort of just, the evidence just started being let. And you have to be very aware of these kind of things and be very careful about it from our side, because the other side would not even necessarily object. But I see Anand has got his hand up. He may have some more on this kind of thing.
I think that's really interesting.
Mr. Maharaj, your hand is up. You're muted. We just need you to unmute.
And your face has disappeared.
Right. Hello.
Hi, we can hear you.
You can hear me now?
Yeah.
Okay. I'm just thinking aloud about the Convention Against Torture. The Article 1 provides for torture evidence to be excluded totally, no exceptions in terms of fairness, in terms of Key's case. The scenario I'm thinking about is the following. What happens? An accused person places a bomb in a school full of children, and the police extract that evidence through torture or assault. That evidence is going to be excluded in the light of Convention Against Torture. I'm trying to balance the interest now. You got a bomb that's going to go off and kill children, And you got a situation where the police assault the suspect or accused in order to get that evidence as to where that bomb is. And CAT tells us that that evidence can never be admissible. I just wanted to know what your views on that are.
You know, it's usually a problem we give our students in class. But fortunately, we haven't in reality had to deal with such desperate choices. But the cases so far look very seriously at what the constitutional breach was. And there's no doubt that the Porto Convention and Section 35.5, the evidence will not be allowed.
Admissible. Yeah. And then finally, my colleague mentioned about, beyond reasonable doubt. Didn't the Constitutional Court in State versus Zuma, the 95 case, decided that evidence in a trial within trial has to be established by the state beyond a reasonable doubt? There's no balance of probabilities or anything of that sort. It's the test has been settled as beyond reasonable doubt whenever it came to admissibility in the trial within trial in a criminal matter. Would you not agree with that?
Well, I think it's, as far as the Section 35.5 jurisprudence goes, the reason I come out in favor of a framework that says factual allegations do have to be proved beyond reasonable doubt is because of the Zuma case. But there are other cases that then go, we don't want any burden of proof. Following after 1990. But that is why my framework would require the state to prove factual allegations.
No, that's fine. Thank you. Thank you so much.
Thank you.
Thanks. Do we have any more questions from the floor? Let's see, nobody. You've all had a long, hard Monday, it looks like. But yeah, so I think just if there's no more questions, then just a reminder that what we will be doing is putting the recording up. I will send you the link. It will be on Law Library. We will also create a collection of the case law, if we can find it, the case law that PJ referred to. So you will have that full resource pack available to you. It's freely available, and I'll send you through the link. And then also just to let you all know what we're also providing to you is what we call virtual clerks. So they are postgraduate students, PhDs and master's students who are trained how to provide research to judicial officers. So they're trained how to write a legal memo and how to provide research to a judge. They also sign a confidentiality agreement with us. And those researchers are available to you. And I'll also send out the process on how you can ask for research support. So that's for us, it's a two-way thing, is that what often our students complain about is not getting very much practical work experience. So it's an opportunity for them to have great exposure to practical work experience, and for you also then to get research support, because we know that as presiding officers in the regional courts, most of you don't have, I don't think any of you have research assistants. So we will be providing that to you as well. So, and also just PJ, thank you so much. That was a really great start to kicking off the webinar series. Much appreciated. And thank you all for coming. It was a great turnout. We had 60 of you in the room, which I think is fantastic. And we'll let you know when the next one is and what the topic is. So thanks, everyone.
Thanks, everyone. Thanks for the questions.
Thank you.
Bye.
Thank you.
Bye.
Bye.